Good afternoon, everybody. This is Jed Marcus, and you are on the Bressler webinar, Turning the Page on COVID-19, Employment Issues Businesses Will Face as the Country Gets Back to the New Normal. If this is not the webinar you signed up for, there's probably another webinar you should be attending. Anyway, my name is Jed Marcus. I'm the co-chair of Bressler's Labor and Employment Law Practice Group. Welcome to another in a series of webinars dedicated to assisting our clients and our friends in working through all the different challenges presented by the COVID-19 pandemic. Our 11th program in the series, Turning the Page on COVID-19 and Employment Issues, will discuss consideration and best practices when returning to work, key online COVID-19 resources, litigation trends, and other related issues. By the way, for those of you who are going to need CLE credits, I will be announcing the CLE code at various points in the presentation. This is to ensure that you're not cheating, I guess. So very quickly, I will introduce you to our participants, after which they each will just hand over the program to the next speaker. First is MJ Dobbs. She'll be talking about returning to work. What should employers anticipate? MJ is a partner, handles all issues of employment for a variety of clients, including, well, every aspect of employment, and also does work in the commercial litigation for transportation companies. Also speaking on key online resources, Emily Bordens. Emily is of counsel, handles all different kinds of employment matters, a lot of counseling, litigation, a real expert in this area. And another expert is John Miller, another partner in the firm, and he'll be talking about COVID-19 litigation trends. And without further ado, I turn you over to MJ.
Thanks, Jed. I'm going to talk to you today about the practicalities of returning to work and what employers should anticipate. And when I was getting ready for the seminar, it brought me back to about a week and a half ago, where my 21-year-old son said to me, "Hey, Mom, let's watch a movie from the olden days." So we rented Trading Places, starring Dan Aykroyd and Eddie Murphy. And for many of you that remember that movie, Dan Aykroyd was a white shoe elitist stock trader. He worked for a fancy bank. And Eddie Murphy was a shrewd and crafty homeless man. And the owners of Dan Aykroyd's bank placed a bet. And under that bet, Dan Aykroyd lost everything. He lost his job, his reputation, his money, his home, his girl. And they replaced him with Eddie Murphy. And when Eddie Murphy realizes that there was this bet, he finds Dan Aykroyd at his lowest point, and he just took a pile of pills, and Eddie Murphy gets him in the car, in the limousine, brings him back to his home. A doctor treats him, and Dan Aykroyd wakes up, and he looks over at his butler, and he goes, "Oh, I had the most awful dream. I lost my job and no one liked me." And then he looks at Eddie Murphy and he realizes it wasn't a dream. So what's my point? My point is that when many of us at some point, sooner rather than later, are going to return to work, we're going to look at each other and it's going to feel like at first that we were in such a bad dream. And then we're going to look at our butlers. "Oh, I don't have one at work." But we're going to look at each other and realize that we are going to need some help getting back to work and getting back to normal. So let's go through some things that I think you have to be ready to anticipate. The first is, before you do anything, you need to welcome your employees back. Everyone is going to be concerned. Everyone's going to have stress about what's going on. So it's important that you communicate with your employees before you come back to work as to what's going on. You should come up with a written plan and guidelines, and I'm going to go into some of that. But most importantly, and Emily will be discussing the specific guidelines from the government helping us get back to work. most importantly, the takeaway that I found when I was preparing for today is that what's being stressed by the CDC, the American with Disabilities Act, and everyone is that gone is the culture of let's just all go to work, even if we're sick. Let's get the projects done. That culture will not fit into what we're trying to accomplish here. You have to stress to all your employees from the top to the bottom that if you're sick, you cannot come to work. And that's something, if you're going to take, that's one of the main takeaways I think you need to be prepared for coming back to work in COVID-19. So let's go through the popular questions that we've been getting for this seminar about what to expect when you go back to work. And the first is, does an employer need to clean and sanitize the workspace? The answer is a resounding yes. There are actually guidelines from the CDC, and Emily will talk about a website from the CDC for folks in office buildings about what to expect about cleaning and sanitizing the workplace. But absolutely, and you need to come up with a plan that's going to reduce the stress and the concern of your employees. It's cleaning and sanitizing, social distancing and hygiene, and screening employees and visitors, and we're going to go through that. Think about your workspace while you have the time right now about the sanitizing, the cleaning. How often do you have cleaning people come in? What kind of things are they going to do? There is guidance from the government. We'll do some of that detail with when Emily gets to speak, but you have to come up with a plan. It really can't just be someone comes in at night and vacuums and cleans out some garbage cans. It's going to be more than that. If you're in an office building, you do need to talk to the building folks that run and manage your building as to what their plans are for the cleaning and sanitizing of the building. Think about your kitchen and your gathering areas. Do you want to restrict access? You should. Simple things. Take out the kitchen table and the chairs that's in your cafeteria or your kitchen. How many people for photocopy in the photocopy room? How many people in the bathroom? Are you going to restrict that? Eating at your desk should be welcome. Tell your employees to go take a walk during lunch. You should have ample supplies of hand sanitizer, soaps, receptacles. And as to face coverings, yes, you should have face coverings. I mean, right now we have the executive order that requires employers of essential workers to provide them. You may expect that to be another executive order as we open up, but if you look what's going on around, pretty much everyone has face masks. But our suggestion to all employers is you should have them at your place of employment. People are going to forget them. You're going to have visitors at some point that may not have them. So you should have them available. It's not going to be an OSHA problem. OSHA requires employers to provide their workers with PPE, with personal protective equipment. Why should you care? Why should you go through all this? And there's two things you need to think about. Number one is nobody wants to be the Tyson processing plant where you have an outbreak. I can't even express to you what that would do to your place of employment and your productivity. Second is New Jersey has not passed it yet, but it is pending. Other states, including California, have already passed laws that there's a presumption that if you get sick from COVID-19 at work, there's a presumption that's a work-related injury. So that's something that you really should consider when you're talking about sanitizing and cleaning the workspace. Social distancing, yes, it's what needs to be done at work. It's the guidelines by the CDC. What kind of things should you think about? Phasing in employees, still allowing teleworking, limit meetings, events, social gatherings, staggering start times, stop times, and remember, and this may come as a shock to some of the people who work for you, you can make a 7-day work week. It doesn't have to be a 5-day work week. You can accommodate people by working Saturdays and Sundays. It doesn't have to be a Monday through Friday. And we'll go into that a little more about dealing with people with childcare issues. That may be an option for them. The CDC has come out with guidelines, no handshakes. I think they even got rid of the fist bump. We shouldn't be doing that. Maybe we shouldn't be doing that anyway. Are you going to restrict travel? Is it going to be essential travel or non-essential travel? There's no right or wrong answers to any of these questions. These are all things you need to think about getting back to work. How are you going to handle conferences? How are you handling deliveries? And not just deliveries you're making, how are you handling deliveries to your place of business? Where is the person putting down the water, the paper, the soda? Are you leaving it outside? Are you bringing this person into your place of employment? Those are things that you should think about. Obviously, increasing space between desks, installing partition shields, closing off common areas. There's OSHA issues. You can talk to your building if you're in an office building. Are they making any changes to airflow? And again, face coverings. Can an employer screen visitors, employees? Yes, absolutely you can. I recently watched the Michael Jordan Last Dance series, and they talked about when the Chicago Bulls would play the Detroit Pistons, and they were called the Bad Boys. And they had something they made up called the Jordan Rules. And the Jordan Rules were all the things you got to do to stop Michael Jordan that the refs let you do. Everything got a little more lenient. Well, we have the Corona rules, the pandemic rules, like the Jordan rules. Everything now is a little more relaxed. So the ADA is letting you do things that you wouldn't normally expect to be doing. You have some leeway. So for example, temperature checks. Absolutely. You can do temperature checks at work. You can do them. You can ask employees to do them at home. If you're going to do temperature checks, you got to think about the following. Who's doing them? What temperature number are we using? Usually it's supposed to be 100.4. Are we going to have lines at work for people to get into work on temperature checking? Some employers are going to just require that employees confirm that they took their temperature at home. You do not need written consent for the temperature checking. I just want to see if we can go through my notes here. This is a document. I put it up here. It's a model sample of employee screening procedures. This is something that an employer can put together, outlining to the employees what's going to be required for them going back to work, that they are going to have their temperature checked, telling them where, telling them when, that they have to confirm that they haven't had a fever, they have to confirm how they're feeling. And again, reminding employees that they cannot come to work if they're ill. And we put this up on the on the webinar, so you can use it as a model to base some of your protocols on. Here's another great example of putting a sign up outside your place of employment, warning people to stop, that they cannot come into your facility if they've had close contact with someone with COVID-19 in the last 14 days, if they've had any symptoms. If you don't feel comfortable putting together a questionnaire for your employees to fill out every day, this is a reminder of your employees to see when they come into all entrances that they cannot come into the building if. Same with the visitors. You can require medical testing. You can require employees to go through COVID testing. The EEOC has said that COVID-19 is a direct threat to the workplace, and that an employer can administer COVID-19 testing. We talked about the signage. Can you inquire every day if the employees, can you have the employees fill out a questionnaire? You can. There is an issue right now as to whether or not that's too much of an invasion of privacy, whether they should have to hand it into their employer, but you certainly can give your employees a questionnaire where they discuss, or an outline, and I think I have it right here, a COVID-19 employee self-certification return to work, where they can fill one out every day that they have taken their temperature, that they don't have any symptoms. It's a little dicey right now. We're going to wait for some guidance as to whether that has to be provided to the employer, but it is a form that you could use when you're considering what to do with your employees to make sure that they're ensuring that they're safe to come into work. What do you do if an employee objects to the temperature taking or any of these issues on a religious basis or other issues? Employers right now are not required to satisfy religious accommodation, as COVID-19 is considered a direct threat to the workforce. But what you can do is you should absolutely consider reasonable accommodations. You could have a person who doesn't feel comfortable having their temperature checked in front of other people. They can move to a private area. So don't forget that you can accomplish many of these things just making reasonable accommodations. Is the employee working when getting screened for COVID-19? The answer is yes. If you have a non-exempt employee, they have to get paid for this. And you're only talking about a very, very quick procedure if you're doing the non-touch temperature scan. How should employers handle employees with children who have no child care? I think we know from Governor Murphy that child care is supposed to open up. June 15th, you can obviously expect there's going to be employees who are uncomfortable with that. What we are suggesting to employers is, to the extent you can, you need to be flexible with your staff. You want people to come back to work. You want people to feel comfortable coming back to work. You can change an employee's hours. Again, 7-day work week, not a 5-day work week. There's going to be issues still that we have last from the executive order, whether they have to be paid for childcare issues. We're going to wait to see what happens with Governor Murphy on that, whether there's going to be an 80-hour requirement for that. But try to be flexible with the childcare issues to the extent you can, and we can certainly deal with family leave issues on that as well.
Okay, I'm only interrupting because I'm now supposed to give those of you who need CLE the CLE secret code, which you are going to have to write down someplace in order to get the credit. And the word of the day is temperature. I will repeat that at some point. This apparently is designed to make, because apparently the state believes that all lawyers cheat with their CLE, so you have to do this. Okay, our next speaker is Emily Bordens.
Oh, no, Jed, I still think I have a little more time to do.
Oh, do you? I'm sorry.
Yep, that's okay. This is probably the critical part of my presentation, which I think everyone's afraid of, is, and it's going to happen. What happens when I have an employee that has COVID-19? Okay, 3 things, and I'm going to go through each one. Talk to the employee. You got to notify the other employees. You have to clean and disinfect the work area, and you got to be ready to answer questions. I'm going to take the last one first. Get a point person, appoint a point person at your place of employment to handle these questions. Have 1 person or 2, but not the whole world. Have people ready that can deal with these issues. You are permitted under the rules, under the ADA, to talk to the employee. You have to have a very frank discussion. When did the symptoms start? Were you diagnosed? Have you seen a doctor? You need to go see a doctor. Most importantly, who have you been in contact with at work in the last 14 days? It's not just employees, customers, other third parties. Did you go to any meetings? If you have delivery people, who did you make deliveries to? Any vendors? Immediately tell the employee they must stay at home and they have to be at home for 14 days. Now, that may change a little bit, so now there's more testing available. And so maybe that period is going to get a little bit shorter as we go on, hopefully. But that is absolutely exactly what you need to do. We can table for when Emily talks about whether these people need to be paid. Now you need to notify the other employees. Here's the not so tricky part. You absolutely have to notify the employees that worked in close proximity. You should notify your facility that someone has tested positive for COVID-19. You are not supposed to tell them who. Well, guess what? We can all laugh. Everyone's going to figure out who it is. I mean, that's just ridiculous because the person's not going to be there and their area is going to be clean and sanitized. But the government tells us you're not supposed to tell them their name. Try to do it in a gender neutral manner and come up with a statement. It could be something that one of our employees that tested positive for COVID-19. They're being checked out by the doctor. We'll get back to you with more information. We're cleaning and sanitizing the workplace, and we will work with the building owners and the medical doctors for this employee's return. But this is imperative that it must be done. Someone raised a question as to whether if you're in an office building where you need to notify the building. I believe the answer is yes. Just as much as you want your building, you need to talk to people in your building. You want to find out from them if someone in the floors below you or above you tested positive. Do you need to shut down your place of employment? No, but probably do need to clean what you're saying is the common areas. Do the cleaning and disinfecting, particularly the workspace where the person was. I think the CDC advises that you should wait for as long a period of time as you can before you start cleaning. This may sound kind of silly because we certainly don't have windows in our building, but the CDC tells you open the windows if you can. I don't know a lot of people can do that. When you're talking about the cleaning, though, it's not just the person's workspace. It's the bathroom they use. Were they in the kitchen? Where do they spend most of their time? And then you must tell the other people in the office what steps you are taking. So be prepared to have a point person available to be able to express what's going to happen. And this is something I think everyone needs to anticipate, because it's going to happen at some point to all of us. Let me get to the next slide. Can you hire during a pandemic? Of course you can hire during a pandemic. I just hired somebody during the pandemic. They haven't started yet, but we did hire someone. And once you've made your offer of employment, you can ask the pandemic questions. You can ask them whether they've had with someone that has symptoms and that they have to be symptom-free before they start. You can certainly delay the start date. I just found out about a friend of mine's employer that is requiring and paying for everyone to have the antibody test to try and make a decision of who can and come back and can and cannot come back to work. So the next big question is, what happens if an employee does not want to come back to work? Okay, the short answer is you got to come back. There are going to be issues that come up, but that is the short answer. There's no special rules for anybody. The job is ready for you, and they need to return to work, even though they may find that they're making more money on unemployment right now. The CDC has identified older adults and people living with older adults that people could have an elevated risk. How do you handle an employee that feels uncomfortable coming back because of those reasons? Go back to your the American with Disabilities Act, engage in the interactive process. Can this person have an isolated workstation? Can they continue to work from home? Ask for a doctor's note. You can even put questions for the doctor to explain what the job requirements are. Can the person come in really early and leave early? Or how about they work later at night? But just because someone doesn't feel comfortable coming in does not automatically require them to have any accommodation or reduced work schedule. Engage in your interactive process. What I suspect is that a lot of people are going to be excited to come back, and a lot of these issues are going to come up about 2 or 3 months from now when everyone gets a little tired about this. Furloughed employees. You do have to tell the Division of Unemployment that the person's been called back, and you need to talk to an employee who does not want to come off furlough and still wants to collect unemployment, that you are reporting this to unemployment. And if they do not come back, you need to document it, and you need to put it together that in 3 days it'll be considered job abandonment. But you got to warn this employee who doesn't want to come back that the information is being reported to unemployment, and that they have to be careful how they certify to unemployment about their availability to return to work. Here's that self-certification checklist I talked to you about. Whistleblowers. John Miller will touch on this more. This is the uptick I think that John is going to be very concerned about when he talks to you. If employees complain about workplace safety, are they considered whistleblowers? Generally speaking, the answer is going to be yes. You can expect, all of us, no matter what kind of facility you have, that you're going to hear, Susie's not wearing her mask, Jed's not washing his hands. What are you going to do about those things? I think what we discussed here today at my office was, let's appoint a point person, just like we talked about employee getting sick. Have a point person in place to deal with the complaints and the concerns. So this way you have 1 or 2 people at your facility that are dealing with it. You don't have multiple principals telling everyone what should or should not be done. The complaint should be taken seriously. The complaint should be looked into. The complaint should be responded to. Document what you're doing, because if there's an issue down the road that employee is going to lose their job, you want to make sure that you have buttoned up what you needed to do from the whistleblower point of perspective. And the employee may or may not have valid concerns, but they're definitely worth listening to. You can document them, and you can tell the employee what kind of action you did or did not take with respect to the employment. The whistleblower lawsuits have already started. That'll be touched upon briefly by John Miller. Lastly, and I want to get to, this is a recall to work notice that you can send to employees that are off on furlough about what you expect that they should come back. It's a good form to use, especially advising them of job abandonment. But let me leave you with 2 thoughts. One that just came up recently was employee waivers. Can I have the employees sign waivers when they come into work? Can I have customers or vendors sign them? You can, they're not really effective. Employees can't waive their workers' compensation rights. You can't force them to waive them. An employer can't waive their requirements under OSHA. The optics are bad, telling employees to come to work and then, by the way, sign a waiver. So what we're suggesting is doing the employee questionnaire about health and safety, putting your sign on the door about what you're doing to protect employees when they're coming in. Let me leave you with these final words. I think the issue that many of us are going to deal with is not so much what happens right when we come back. I think the greatest concerns we're going to have is how we're feeling in September. What we're talking about today is going to get old, and wearing masks, washing the hands, we hope doesn't get old, but that's what I think you can expect. I think you're going to have a good return to work. I think you've got to get ready for the complaints and the concerns that come in August and September. Emily, I'm going to turn it over to you.
Hi, good afternoon, everyone. Thanks, MJ. That was great. What I'm going to do for all of you is I'm going to take you through step by step some of the key online resources, because this is going to be really helpful in trying to implement a lot of the questions and answers that you're going to face that MJ went through. So the first thing that I think you guys should look at is the CDC guidelines. Now, what you'll note on this PowerPoint is that you'll note that the actual URLs are going to be provided on all these slides, and you should have received a copy of the slides. So after we're finished here today, I'm going to encourage you to really look at these websites in depth. You know, my job and my goal is to try to highlight some of the most important things that you should look at. But there's so much information on these websites that I think you really should take your time and dig through and look at every link and look at these documents, because they are really going to be not only a good defense for you. John's going to be talking after me about some litigation trends, and absolutely what you're going to want to do is you're going to be able to use all the things that you're developing as a defense for why you've made good faith efforts to keep the workplace safe. So the first place you're going to go is the CDC's website. And on that website, you're going to see the Learn More About COVID-19. And when you click that, it's going to bring you to the COVID-19 website homepage. You're going to scroll about halfway down, and you're going to see a link for businesses and workplaces. Okay. Now on this slide, this is going to be your main resource page about where you're going to be able to find all the fantastic information that you need to look at. When you scroll down, there's going to be some business sector calls, workplaces and mass transit calls. These are recorded conference calls with stakeholders that review current CDC guidance and provide stakeholders, but basically people who want to be able to ask questions and more questions and answers. So my suggestion to you would be a good place to start on this website is to go to the workplace decision tool, and you'll see where it says, should you consider opening? So I think that should be pretty much the first step. So what you're going to do to the right of that is a PDF. When you click on that PDF, what it's going to do is it's going to bring open a workplace decision tree. Okay, and it asks three main questions. Should you consider opening? And that's going to be your first threshold question. Are you actually able to open based on applicable state and local executive orders? And then if that's true and you are allowed to open, then you're going to have to answer the second question. Are you ready to take all the steps necessary, as MJ talked about, to be able to protect your employees? Okay, if you're not ready to take those steps, okay, then you should not open. All right. But once you feel that you do have the resources and the financial background to be able to start reopening, then you're going to move to the next step. So this step is this workplace decision tool is really great. It talks about, you know, the next step would be our recommended health and safety actions in place, and is ongoing monitoring in place. Once you meet these three steps, then it says, okay, open and start monitoring. Okay, so the next thing you're going to do, next thing that you can look at, let me go back for 1 second. Let me change the slide. Okay, so this is another great tool, and this should be your next step. It's the interim guidance for business and employers, okay? These guidelines have been updated as of May 6th. So, of course, one of the things you're going to notice is that, and everybody, I mean, this is like the catchphrase. Everybody hears this. It's a fluid situation. Things are changing every day, but it's true. I mean, literally, these websites change every single day. In March, we were told, or the consensus was, don't do temperature checks because it could be an invasion of the ADA. Then a month later, it was like, well, you can do temperature checks, but make sure you have a medical professional do them. Then it was, well, you can do temperature checks, but make sure that you have one key point person do them. Well, you can do temperature checks, but don't line people up. So the point is that, again, I hate to say it, but it is a fluid situation. So this guidance is effective or is current as of May 6th. So my suggestion is that you should continue to go back to these websites to see if there have been any updates. So this guidance is great, okay? This interim guidance, this should definitely be part of what you read to figure out what has to be part of your plan. Like MJ said, you know, doing daily health checks, conducting a hazard assessment of your workplace, encouraging employees to wear face coverings in the workplace, implement policies and practices for social distancing. And here's an interesting one. The CDC would like employers to improve the building ventilation system, which MJ talked about, open your windows, but who can open windows? So my suggestion is that if you are in an office or a building, that you should talk to property management to see what are the steps they're taking to work on that. So so that's a really great resource. So one other thing that I want, now there's no slide for this, but don't be alarmed. There's a tab at the bottom where it says meeting notes. If you click on that, it's going to bring you to a link of something that I want to show you that is kind of breaking, right? Because again, everything changes every day. This is a last minute addition, did not make it onto the PowerPoint slides, but it is COVID-19 employer information for office buildings. Okay, so I'm going to take you there. If you click that link, this is a great resource. So what this is going to do, and of course, every single industry and practice is going to be different. Okay, this resource, this is going to be important for people, employers that work in office buildings, and they have kind of a step-by-step plan of all the different issues that you should be looking at, creating COVID-19 workplace health and safety plans. You know, check with the building to see if the office building is ready for occupancy. This is a really good thing, and this is really should be based on, you know, I think going back to the decision tree is, are you able to open the building? You need to check with your property management company to see, well, is it even ready for you to reopen your workplace? Identify where and how workers might be exposed to COVID-19 at work. So MJ talked about that. Look at the workplace. Are there common areas, meeting rooms, break rooms, cafeteria? Some employers have locker rooms, okay? All of these waiting areas, all of these other areas, you need to take that into consideration. Okay, so going back, I could spend hours talking about this. One other thing that I want to show you on the CDC website is the Resuming Business Toolkit, okay? This is fantastic. It is a PDF toolkit which will take you through step-by-step all the different things that you need to do. And my favorite part of this toolkit is a restart readiness checklist. It is literally a checklist for you to be able to go step by step to be able to figure out what you need to do. Okay, so now what I want to do is talk a little bit about OSHA, okay? OSHA, and what I would recommend, a good starting point is to go to the publications link. Okay, it's on here on the PowerPoint. This link will provide all different fact sheets, workplace notices, recommended posters, These are not like federally mandated required posters. This is not like you have to put this with your poster kit. These are recommended posters, because remember, one of the things that you're going to have to do when you bring your workforce back, and what OSHA and the CDC is talking about, is that you have to provide your workforce with training. And this is a great place to go, because you're going to be able to show your employees exactly what they can do to get ready. So you have posters, you have 10 steps to preparing the workplace, 7 steps to correctly wearing a respirator. Now, I'm not talking about a manufactured respirator. They're talking about N95 masks. They're talking about face coverings. They're talking about cotton masks. So all of these things, this is very important. You can give these to your employees so that they know how to wear them properly. And there's also a training video. And all of these, the CDC and OSHA, they both have training videos that you can use for free to your employees. You may want to have a reorientation session where you want to set up, here's a packet, information. Because of social distancing, you may not be able to do in-person training and fill up your whole conference room with people. But what you might want to be able to do is give employees a packet and give them links to different training videos that they can look at. The one last thing that I want to talk about with OSHA is guidance on preparing workplaces for COVID-19. This is OSHA's publication. Along with the interim guidance from the CDC, I think this is going to be really important for you to read as well. And again, when you're putting together your plans, keep all these documents together, because as John's going to be talking about later with litigation, you want to be able to show, here are all the documents we relied on. These are the steps that we took. So I think that would be very, very, very helpful. So we have about 5 minutes left. So what I want to talk about next is I want to touch upon briefly the EEOC. Now, of course, the EEOC has weighed in, of course, on coronavirus and discrimination, and I think a lot of this might come down to religious accommodation issues. It may come down to disability under the ADA. I anticipate that there are going to be charges of discrimination filed with the EEOC based on COVID-19 issues. The EEOC, the Office of Federal Operations, has issued special instructions to federal contractors. The EEOC has also posted information about enforcement of non-discrimination laws. The one thing that I want to really point out on the EEOC's website is they published a short question and answer document, what you should know about COVID-19 and the ADA. This document, again, was last updated on May 7th. And it is a great resource to help take you through the reasonable accommodation and the interactive process. Now, some of you may remember the H1N1 outbreak. The EEOC had provided guidance regarding pandemic preparedness. This was actually first created with H1N1. It has been updated. Now, again, it has not been updated since March 19th. So again, I would hope that the EEOC would update this document with more relevant information, because as we know, the guidance that we have today is very different than the guidance that we had in March. And finally, with the EEOC, there is a COVID-19 webinar training on discrimination and harassment in the workplace as it pertains to COVID-19. This might be another short video that might be a good thing to incorporate in any kind of reorientation. So I'm almost out of time, but one of the things I want to kind of just touch upon briefly, the U.S. Department of Labor also has an enormous wealth of information. There are fact sheets here on Families First Coronavirus Response Act. There are, with FLSA guidance, do you have to pay someone when you send them for testing? Yes, I would say please pay them while they go for testing, just like you would do if you had a drug and alcohol test or something like that. There are question and answers regarding traditional FMLA and how it could be impacted by COVID-19. Posters I'm looking at it right now, and like I said, everything is so fluid. They actually just posted something called a quick tip. Okay, this is interesting. I'm looking at this for the first time as I'm talking to you. It is a poster about quick benefit tips from DOL. How much paid leave can employees take? So this is great. You could use that with your reorientation packet. They have the workplace poster that you are required to put with your posters. They have a webinar. Again, they have the webinar here. We had been hoping that the USDOL would publish model notices for FFCRA leave. I actually emailed the USDOL to try to get more information about whether they were going to do that. I did not expect a response, but miraculously I did, and the answer was no. So I think the takeaway from that is that we're going to have to do our best to modify the traditional FMLA notices, the WH forms that you can find for designation notice. And that's about it for me. My last slide here, I have some New Jersey resources. My suggestion to you on this New Jersey website, please check it out if you haven't already done so. On the right-hand side, under latest news and information, there is great information for you, including a chart, which will definitely help when taking you through a list of scenarios, what leave is available, and how much leave and how it's paid. So with that, thank you so much, and I'm going to pass the baton to my colleague, John.
Before you do so, John, again, I'm asked to give the code, which is temperature. Also, if you have questions, use the chat feature. You can either do directly to the individual to whom you wish to ask the question, or if not, I'll field it and direct it. Okay? And without further ado, my partner, John Miller.
Thank you very much, everyone. I want to address two things first before I get into my presentation, the reality of what we're dealing with. One, as you can see, I'm not sure which view you have. One side of my face is lit, the other is not. I'm now realizing that my lighting scenario, by virtue of storms that are coming through, was not ideal, which brings us into teleworking. It's always happening. And if for some reason I unfortunately cut out, or fortunately for you, I'm sorry, that's part of the whole quote unquote new normal. I don't like the term, but I'm recognizing that we are all into it. The second of which is everything that MJ and Emily otherwise described just now, I literally had to deal with today with a client. I had a client who otherwise had an individual who did not want to come to work because they had visited Miami, came back and wanted to self-quarantine. There was no issue. They weren't otherwise told by a doctor they have it. And the employer's like, well, keep them working. Then other employees started raising issues. And then the client came back and says, what do I do? Going back to both all the links that Emily just brought up, as well as which MJ just talked about, I implore you, look at those. The second one, you know of someone who has an underlying health condition that might be impacted by potential exposure to COVID-19. Go back to Emily's slides. The EEOC has this direct threat guidance, and I had to counsel them on it. What is in theory is actually real. It's happening, and it's going to happen more often than you think, which gets me to my slides, and which gets us to the reality of what we're seeing, and that is litigation trends. Now, I want to mention, in prior webinars that were put on by Bressler's Labor and Employment Team, they talked about the different types of laws that might be impacted. Today, I'm here to say they are impacted and what's going to actually happen with them. I'm going to primarily focus on employment-related litigation. If time permits and if my electricity and internet connection allows, I'll go into non-employment, which ends up in a, while non-employment, an interesting scenario. But again, I need to reiterate, as many of you in the Northeast are now experiencing, if you're not an essential business, you're starting to open up. Go look at these websites because they will give you some guidance. It may not be the right or complete guidance, but they're going to give you some guidance. With all that, let me now turn to some of the employment litigation related issues. As part of this presentation and my research, I started looking at what I'm seeing, what's out there, what's actually being filed, what can you consider being filed. I'm starting to see actual claims running the spectrum that is under existing laws, ADA, anti-discrimination, but under new laws, FFCRA that Emily mentioned before. And it gives us the opportunity to figure out, all right, how to address and how to deal with these both existing and new laws while we're trying to handle these claims. Employment litigation. As you can see, it literally runs the spectrum. Some of which, as I described, are going to be ones you're familiar with, those who are in the employment law field. Disability claims, discrimination claims, WARN claims, but then you're going to add into that the Family First Corona Response Act, FFCRA claims. It's a template or an offset of what is otherwise brought under the FMLA, but it's got different nuances. There are litigations already starting with that. In terms of the non-litigation or non-employment litigation claims, we're seeing claims that are being brought under the Payroll Protection Act or Payroll Protection Plan loans, which is under the CARES Act. Employee safety beyond just OSHA, wrongful death, and suits against business governments for business disclosure. If I have an opportunity, I'll give you some detail about that. Turning now to the employment claims, in particular the accommodation claims. What we're seeing, and that candidly, I haven't seen it in the actual litigation that has been filed in state or federal court, but has been noted by the EEOC, is that there's been a pretty good surge of charges with the EEOC alleging that employers are not accommodating their disability requests, and they're otherwise referencing the FFCRA. That is, and for purposes of the audience that doesn't know, the FFCRA provides expanded paid leave rights, the first of which is paid sick leave. I'll address that later on. And secondarily, it's an expanded paid leave under the Family Medical Leave Act, the FMLA. Now, when we're dealing with these issues and trying to figure out what's the trend going to be, the New York deputy of EEOC, her name is Judy Keenan, put out a public, or actually was a participant of a webinar or seminar that noted that she's receiving, her agency is receiving, they handle the East Coast or Northeast claims, that she's seeing an uptick in ADA, that is the Americans with Disabilities Act claims, that actually universally are saying that they are failing to accommodate my need to otherwise work from home or work in an alternative setting as a result of some kind of COVID-19 issue. Which gets me to where I started off with, which I think we are all going to have to deal with, and that's teleworking accommodation. I'm proud of my firm and other employers I'm aware of that we're able to pivot to enable people to continue working and doing so virtually, even where it was a non-traditional type of setting. And what I mean by that is an assistant supporting multiple attorneys and doing it virtually. Well, it's happened, and it's happened in my experience successfully. So what does that do? I fundamentally believe that when addressing an employee's request for accommodation, and they say, I don't want to come to work because, and I would like to work from home and I can continue doing what I did, employers are going to be faced with the Hobson's choice. We did it, and it's worked for several months. So how can we explain why we're not going to continue to do it? That's an issue that I think is going to be ripe for litigation. I've not yet found one that otherwise involves that, but I see it coming. Another component, and candidly, it was jokingly said to me not too recently, perceived as disabled. That is, an individual, be it in more likely scenarios, a manager, but a coworker, who otherwise has an employee who, say, for example, coughs at work or exhibits signs, COVID-19 related signs, or is out for some period of time, but obviously you can't disclose to other employees. And people are like, oh, that person is infected with the COVID-19 virus, and I don't want to work with them. If that impacts their ability to perform their functions, that potentially is a claim. And when I say my experience, before this all began, I'm the one that actually said the joke. I coughed. Someone walking outside of my office before all the stay-at-home orders were in place and the pandemic was officially declared, said, "Oh my gosh, get away from me, COVID-19." I took it as a joke, but I can see in the future that those types of issues and those kind of reactions become a very real issue, including in which what Emily was describing in terms of, and MJ, about wearing masks, and we'll get to that in a minute. Which ties to, in terms of protecting people who may have been infected or perceived to be infected by the COVID-19 virus. New Jersey is employee friendly, and for that, I mean, in my business that's great, but I'm okay with it. I agree with it. They're attempting to enact laws that, while in theory I agree with, the way that it's open-ended, I have some issues with. In particular, New Jersey has proposed legislation that would amend what is known as the New Jersey Administrative Code, 12:70, to prohibit employers from terminating or otherwise penalizing employees if the employee requests time off based on an electric or written recommendation by a New Jersey licensed medical professional that the employee must take off a specified period of time because the employee has or is likely to have an infectious disease, which may infect others in the employee workplace. I use the air quotes purposely, not just for theatrics. Now, what does the law as proposed mean? What's going to end up happening is, if an individual who goes to a doctor is otherwise written a note or an email sent saying they're exhibiting symptoms of an infectious disease, which I believe might be COVID-19, I recommend that they be out of work for X period of time. No specific time frame, not the 14 days, but X period of time. The employer must give that individual the time off. The employer must reinstate that individual to the position they held prior to them going out on leave. And that includes bonuses, benefits, compensation, and employment responsibilities. Additionally, as I'm experiencing is the case, if the employer had to replace the individual because that job needed to have someone in it, the employer is required to otherwise put the person in a commensurate spot, which is compensation, job responsibilities, benefits, and likewise. My concern about this, and I can go briefly, it's return to position and there's penalties. I don't see in the proposed legislation that there would be a private right of action. I wouldn't be surprised if that changes in the future, but as of right now, it's the Division on Civil Rights to bring that claim against the employer to say you didn't do this, and there's a $2,500 penalty for each violation. The one kicker to the law is that there is no sunset provision. That means this law, which otherwise piggybacks off an existing law that gives the governor under the emergency health powers to designate a disease as an infectious disease. That means COVID-19, like HIV, and potentially other, and hopefully not, other kinds of infectious diseases are going to be what I would vernacularly call a protected category. So segueing to that, but let's go to existing. So I want to talk about a case that touches on and straddles two areas that I'll talk about. Canuck versus, actually this one's not straddling. Canuck versus Sherman Sterling. Sherman Sterling is a large lawsuit or law firm. What this does is highlight with every employer that might otherwise be thinking about furloughs or layoffs is the importance of doing it right. And in particular, in this case, Canuck was a 62-year-old IT manager. He was terminated. The basis that was given to him, there was a downturn in the legal business, justifying we can't pay you. And then there was an allegation that they claimed that he had some kind of kickbacks from a vendor. Canuck sued the firm. And when he sued, he said that reason, that is a downturn in business and ultimately the idea that there was kickback, was a pretext for age discrimination. And it wasn't just me. You're targeting a population, an older population, and using COVID-19 as an excuse to terminate us. That gets me to just a point, a practical point. If unfortunately employers who are otherwise on this program have to experience the hard decision of we've got to lay people off or furlough them, when doing so, make sure you're doing it in a very methodical and supported way. And by that I mean, if you're going to target a particular type of job, a department, and in particular, and importantly, an individual, make sure you're doing it and documenting it from the beginning. This is the position, these are the jobs, this is the department, and this is why. Because I fully believe that there's going to be an uptick that COVID-19 is allegedly used as a pretext to terminate a class of people. And in this case, it would be the older people. Next, we're going to turn to new lawsuits or claims that are being brought under new lawsuits, in particular, the Family First Coronavirus Act. This act, candidly, it's an addition and supplement to the Family and Medical Leave Act, but it imposes additional responsibilities relative to paid leave. Now, as was mentioned earlier, federal, state, and local governments have enacted COVID-19 specific laws, including the FFCRA. I fully recommend that before any employment actions are taken, in addition to looking at FFCRA and the guidance, look at your local laws, because sometimes local laws are putting more responsibilities on employers and giving greater benefits to employees. In terms of what we've seen via lawsuits that are happening, I'd like to first talk about a unique one, but eligibility for FFCRA. And by eligibility, I mean the following. The FFCRA covers employers that are quote unquote small businesses, that is less than 500 employers. There are exceptions. One, by definition, employers who have more than 500 employees, they're not covered by this act. The exception or exemption ends up being an additional one. Employers who have less than 50 who can otherwise justify why they can't abide by the law, they're exempted. But in this case, and that in particular touches on Ariel Robtoy versus the Kroger, it was the former, and that is Kroger claims not to have to abide by the FFCRA because they have more than 500 employees. Let me give you some of the details of the litigation. Robtoy filed a federal complaint against Kroger alleging that she requested and was ultimately terminated for otherwise asking for leave because of COVID-19 related symptoms and was told by a doctor, quarantine yourself. If you look at the complaint, and I'm happy to provide it to anybody that wants it, Kroger didn't handle this right. They were very aggressive about not being covered. And ultimately, in it's my words, knee-jerk reaction, terminated her employment. And then attached to the complaint were text messages between Kroger and the plaintiff. One lesson, be careful about what you're text messaging. Be careful about your emailing. But coming back to the complaint itself, Kroger made clear, we're not covered by this. Well, unfortunately, and I guess it's fortunate for the parties, but unfortunately for me, I'm not going to be able to see, nor are you going to be able to see how this plays out in terms of the actual argument about not being covered by FFCRA. The reason being is as of May 18th, 2020, the plaintiff voluntarily dismissed it. That said, and as I intimated just a minute ago, use this as a lesson. We're in uncharted territory that otherwise is going to give you, the employer, and if employees are listening, an opportunity to have a dialogue. Don't knee-jerk. Hear the issue, hear the request. There are guidance from the EEOC and otherwise that can give you the ability to say, all right, hold on, let's figure this out. You may be put in a hard spot that says, we can't accommodate this. You're not entitled legally. But do you want to be the next Tyson? Tyson Foods was sued for not giving social distancing, and it blew up. And I suspect that their business model and their earnings went down. Do you want to be the next one? I recommend not knee-jerking. Rely on your in-house counsel. Otherwise, go to outside counsel, talk it through to see what are your legal obligations and what's sort of in between. Next issue I'd like to talk about relates to actual adverse employment action for requesting FFCRA type leaves. This one is Stephanie Jones versus Eastern Airlines. This relates to the enhanced FMLA leave. And what by that I mean, and let me just reiterate for those that are attending, the FFCRA provides for two different components of paid leave, one relating to sick leave, one relating to enhanced paid FMLA leave. By virtue of the time that we're running, I'm not going to go through them, but in particular, this case relates to taking FMLA enhanced leave to care for a child who can't go to school. Jones was a former director of Eastern Airlines. She filed a complaint because she requested leave to enable her to take care of her under 18 child whose school was closed because of a statewide closure order. You can see in the complaint, to the extent you want to read it, they were pretty short with her, and they denied her the request and otherwise terminated her employment for not coming back. She filed a complaint, FFCRA and FMLA interference, and FMLA and FFCRA retaliation. The unique part of this case, and it's still active, is whether the FFCRA provides for individual liability, because she named the individual managers. I think she has a legal hook because the FMLA provides for individual liability, but this case will determine whether, in fact, the extension of the law also extends individual liability.
John.
Yes.
I just wanted to interrupt to repeat. The first CLE code is temperature. The second CLE code is check. And it's also included in the chat, the group chat, those two things.
Thank you, Jed. Appreciate it. Now, I recognize my time is running low, so I'm going to blow through these so I don't keep everyone on the call or the webinar unnecessarily. You're always willing or able to reach out to me, jmiller@bressler.com. So very briefly, I'm going to talk about, on high level, additional employment laws, and potentially we might get to some of the non-employment laws. The NLR, National Labor Relations Act, provides for protection where employees, both unionized and not unionized, have the ability to engage in what is known as protected concerted activity. That is, talking about workplace issues. Maine Coast here was a unique one that was brought up, and it otherwise addressed an employee who wrote a letter to the newspaper complaining about workplace issues, and in particular safety issues. She was disciplined and otherwise suffered an adverse employment action, and as a result of that, she brought a claim through her union. The NLRB found that, in fact, her activity was protected by the NLRA, that it was concerted or protected concerted activity. I envision that there's going to be a lot more of that, because I've heard about Facebook postings or groups by employees who otherwise are complaining about workplace environments and employment actions taking place as a result. That's, even if not unionized, that's protected concerted activity. Whereas the NLRA, that is traditional labor, had in the past really been sort of the spearhead for new claims, I can see that happen. OSHA claims. I'll talk very briefly about it. This is going to come up, not so much necessarily in the OSHA enforcement context that employers are going to face by virtue of an employee, but more generally speaking, it's going to tie to retaliation claims. But I will tell you that OSHA recently published that they received between January and March 3,000 additional claims related to COVID-19 employment safety issues. As a result of that, on April 20, they felt compelled to push out a press release saying, employers, you must be aware, or let us remind you, that you cannot retaliate or take adverse employment action against employees who raise workplace employment claims or issues. Unfortunately, be careful what you wish for, because as a result of that, and the spike in the claims that were received, OSHA recently issued in May a notice that they are having to go through an audit of their complaint procedures, in particular the whistleblower complaint procedures, which as a part of it says we have to look at how the COVID-19 is impacting our COVID-19 complaint process. Read between the lines. They have too many complaints come in and don't have enough people to investigate or otherwise adjudicate them. So when are you actually going to hear about it or actually face that enforcement? I don't know that's going to be quick, but understand as soon as they have the ability, and they are encouraging people to make complaints, you're going to end up having to face a potential OSHA investigator coming in saying, where's your reopening plan? And are you complying, as MJ described before? Wage and hour claims. This is going to come up in a couple contexts, and I'm going to keep it short. The case that I note here, MAC versus HC Air Systems, I'm going to combine that with a whistleblower claim. What's happening with the quote-unquote essential businesses is that while other businesses are shut down, you've got essential businesses whose business is actually ramped up and employees are working more. In this particular case, this was an HVAC IT or tech person who was going out to the field and had many more calls than he had otherwise experienced or thought that he was going to have, raised the fact that he wasn't being paid for overtime compensation, and otherwise made a complaint about it. In terms of retaliation components, we can blow through the other slide. He also said, you're not giving me enough or sufficient personal protective equipment, PPE. Shortly after he made these complaints, his employment was terminated. Those results in the lawsuit, which are one of the first that you see relative to wage and hour as a result of increased COVID-19 business and also complaining about PPE. Another thing, as I mentioned before, is the fact that we're all working from home, or at least most of us, timekeeping, where you have non-exempt employees who are now for the first time working from home and remotely. I implore employers to make sure that their systems are either hopefully online so the individual can actually log in and enter their time. And if you don't, get back to it and make sure that the time is being recorded correctly and on a accurate and timely basis. The reason being is if employers are not having those systems in place and an employee otherwise says, I was working those hours and you don't have the records to back it up, you're going to end up being on hook because the presumption is the employee's time work is accurate, disprove us. And finally, temperature checks. I'm not going to go into great detail on this, but it's going to come up and it's already happening. Temperature checks can be compensable and they are not necessarily compensable. It truly comes down to whether, in fact, the temperature check is indispensable to the function that the person's performing. That is going to be such an issue in an employer and position-specific inquiry. But before you require someone to come back and refuse to pay them, ensure that you're looking at the existing law. In the analogous scenario is security checks. Security checks are, if it's not integral to the position, even if it's 25 minutes, you don't get paid for it. On the flip side, whether you have butchers who are in a meat packing or a meat processing plant and they have to sharpen their knives, the courts have found that that's integral. You have to sharpen your knives to conduct your business. Please do, before you make a knee-jerk decision, make sure you're looking at whether, in fact, you have to apply or comply with the wage and hour laws. And finally, and we are not going to end up getting to the non-employment issues. If anybody wants to talk about them, I'm happy to do so. Whistleblower claims. Every state has some type of whistleblower claim. So understand where an employee complains about an environment that they feel is unsafe, either work-wise or otherwise. They are otherwise going to be cloaked in the protections that are provided by state and candidly federal employee whistleblower protection laws. I mentioned before Mackey, he brought up the failure for PPE. Florida, California, New York, New Jersey, and Virginia prohibit retaliation against employees for reporting violations of health and safety laws. California, New York, New Jersey, Illinois, Michigan, Texas, and Wisconsin go even deeper. For employees working in the healthcare field, that's a specific law. And so I caution those that are attending that where you have complaints, including not wearing a mask, take it seriously, because that right there could be a whistleblower claim in the making. And finally, workers' adjustment and retraining notification, otherwise known as WARN. Those are already happening. The takeaway from this, without going into great detail, is that if you have or need to engage in a layoff or a furlough, before you do so, make sure you're complying with state or federal and state laws, because there are requirements. WARN requires 60 days advance notice before you otherwise do a mass layoff or plant closing. New Jersey, aka a mini WARN statute, imposes a 90-day with additional requirements in terms of pay, which is severance. Do not just tell people that we're laying you off, as was experienced by Scott versus Hooters. Hooters had 700 employees. All they did was say, you're laid off. They didn't give any advance notice. By virtue of all the CDC, OSHA, DOL, all the guidance being put out as early as January, the employees that filed this class action said that the employer, that is Hooters, had enough advance notice that they might have to lay people off, sufficient with which to otherwise give them notice. As a result, they violated it. I will tell you that ultimately there are so many different avenues of this. There are so many different areas and gray areas that deal with this that I don't look for the business necessarily, but employers, people who are listening, should take very seriously, before you take an employment action that might otherwise be COVID-19 related, take a step back, figure out what laws apply, see whether you're covered, and even if you're covered, see whether there's other guidance that might be provided by in-house counsel, HR professionals, or outside counsel. And Jed, with that, I'm going to stop there.
Thank you very much, John. Excellent. Now, there are a couple of questions asked by our attendees. So I'm going to ask the question and I'll direct it appropriately. This is for you, MJ, from one of our friends out in the hinterlands. Do you recommend to conduct preventative decontamination cleanings of the facility on a routine basis, or is it okay to decontaminate only after a case has been reported?
You've got to be proactive. So we recommend that you be proactive and you start the decontamination process now. The issue is going to be, how are you feeling come September, October? So I hate to sound like Emily, you got to be fluid. So I think right now, coming back, you should be more proactive. You may be able to slow things down, but then when we start hearing about the uptick that we're supposed to get in the fall, start being proactive again.
Thank you. Now I want to ask, this is for Emily. If an employee is sick and goes home for 2 weeks, but can work during that time, is that still considered PTO?
Okay, so the Department of Labor actually kind of addressed this in their FAQs. So if an employee is actually sick, they should not be working. They should use their PTO time. If they're home caring for other people and they're not sick and they can work, then they can work from home and not use PTO time. So, you know, my recommendation is that if an employee says to you, I'm sick, I can't work, then you should tell them, use your PTO and take the time off you need to get well, because every good deed goes unpunished. No good deed goes unpunished, like Jed says. So we don't want someone to be able to say to you later on that an employer made them work while they were sick. So that would be my recommendation.
Now,
and Emily, before you go on, I just want I didn't have a chance before, but we'll do it now. Emily's recommendation and advice is right on point. Another layer of consideration is, what did the employee tell you why they're sick? Does it then trigger FFCRA leave? And let me just describe to you, and I'm going to read it briefly. Those who've got the CLE credits, feel free to log off. I hope you stay. There are 3 that otherwise is the paid leave, which is unique to federal law. And there are 3 that is an expanded FMLA leave that otherwise provides paid leave. The first, and the EEOC has said you can ask these questions of the employees to the extent it's unclear, as well as the DOL. First is the employee subject to a federal, state, or local quarantine issue order? If they are and they're not working, then they should otherwise be given the paid sick leave. And I know that doesn't touch directly on Emily's issue, but for the fulsome response. Next is, has the employee been advised by a health care provider to self-quarantine? If they have, they're eligible under the FFCRA, so long as the employer is eligible for paid sick leave. And that the paid sick leave is 80 hours of paid sick leave on a reduced rate. It's not full rate. We can give you more of that detail if you need it. And third, finally, for paid sick leave, is an employee experiencing symptoms of COVID-19, not yet diagnosed, but is seeking medical assistance. That's paid sick leave. The next 3, that is touching on the FMLA. Is the individual caring for an individual who is otherwise subject to a quarantine or isolation order, or has been advised by a healthcare provider to self-quarantine? There's some nuances there. But if you're the person says, I have to stay home or I'm sick, and granted, again, it doesn't fall on Emily's, that potentially gives them the ability to take the expanded FMLA leave. Next, more touching on, not so much touching, employees caring for her child who is not otherwise able to go to school because of a closure order. That's it. The final one that touches on Emily is the employee experiencing a symptom that a federal or state health department has declared is a potential symptom of COVID-19. That may entitle them to the FMLA plus leave. I only mention this and interject is the PTO is there. However, there's guidance from the DOL about whether you can force someone to take PTO or whether first they're entitled to the FFCRA leave. An inquiry, an exchange should happen between the employer and the employee to find out whether any of the issues they're experiencing fall within the FFCRA. If not, then it defaults right to Emily's recommendation.
Okay, and then finally, and then we got to wrap it up. I'm going to direct this to Emily again. For the FFCRA, Emily, the first 2 weeks, mandatory paid sick leave to take care of a child under 18. Total weeks, 12 weeks. What's the very quick skinny on that? And very quickly, please.
Yes, the answer is yes, it's a total of 12 weeks. So the first 2 weeks of the 12 weeks can be under the Emergency Paid Sick Leave Act, and then the remaining 10 weeks would be under the expanded FMLA.
Excellent. Okay, so that's it. I just want to mention to people. Oh, yes, MJ.
No, I'm just saying goodbye.
Okay, just we're having a webinar next week. If you're interested, regulatory and litigation issues that registered investment advisors will confront. And on that note, you can always reach us at any time, but thank you very much and goodbye.
Thank you, everyone.
Thank you.